Namaste. India, that is Bharat, is considered as the Vishwaguru. Bharat is enlightening the world with its treasure of knowledge. In modern times, personalities like Swargiya Ra Venuvetan attended the international seminars to enlighten the world. Swargiya Ra Venuvetan had picked his right successor. My humble pranams to Swargiya Ra Venuvetan. He chose Advocate Saji Narayanan as his successor to attend the seminars in International Labour Organization. Advocate Saji Narayanan, who is the national president of Bharatiya Mazdoor Sangh, which is Asia's largest trade union, is attending International Labour Organization seminars since 2009. Advocate Saji Narayanan had enrolled in 1981. He has kindly consented to deliver a speech on the subject Labour Laws and Amendments. I invite Advocate Saji Narayanan to enlighten us on this subject.
At the inception, I would like to compliment the organizers for bringing up for discussion a vital subject that is widely discussed in the labor sector, that is labor law amendments. For the last 6 years, the labor law amendment has come to center stage because the government has been trying to codify, consolidate nearly 44 central labor laws into 4 codes. So BMS has been in the consultation throughout. So I'd like to share my experience in such discussions. There are many contentious issues. All these 4 codes are voluminous, so it's not possible to go into details of each and every provision. But I would like to present some of the vital changes and also some of the contentious issues involved. Now, when we look at the labor law history of India, during ancient times we had labor laws. Scriptures, literatures like Sukranidhi conveys the condition of labor laws in those times. During the British period, a slightly labor law benefiting the worker came up in a very, very meager way, light way, when the British government enacted the Factories Act of 1881. Thereafter, we had the Trade Union Act of 1926. Then came the Trade Disputes Act of 1929. And there were some such laws have come into being. But the labor law reforms in the country got a human face during the time of Dr. Ambedkar. Ambedkar was inducted as the labor minister in the Viceroy's Council in 1942. During his tenure, he has initiated most of the basic labor laws in the country. Thereafter, there are some milestones in the changes in labor laws. For example, in 1957, there was an Indian Labour Conference where the parameters of minimum wages were fixed. Thereafter, the Supreme Court widened that parameters in the famous Raptakos Brit case. Then there was an attempt at the central level to review the labor laws in the country when the government appointed the first National Commission on Labour in 1966. Thereafter, in 1999, again, the Vajpayee government appointed Ravindra Verma Commission, the second National Commission on Labour. that also submitted its report. Many of the labor law changes that are taking place is based on the report given by Second National Commission on Labor. When we look at the drafting procedure, drafting of our codification, etc., there was an attempt by Indian Labor Association in 1994 when they drafted a single labor code for all the labor laws in the country. So such attempts were going on. When we talk about codification, simplification, amalgamation, these are all welcome moves because we cannot manage with a plethora of labor laws with conflicting provisions. So it's welcome. But what should be the purpose of labor law changes? That is very important. Now it is well settled that the purpose of labor laws are mainly three. One is industrial peace. That is the most important. There should not be conflict in the labor sector. Industrial peace should be established. Only in a peaceful atmosphere can industry move forward. And second is labor welfare. And third one is the industrial progress. So these are the purpose to be achieved by labor law reforms. So, but unfortunately, what happened to India was after independence, till 1990s, we had to experiment the Russian model of socialism, where the fundamental principle of labor relations was that industry versus labor. That means industry and labor, or the employer and employee, are two rival classes, and they are in constant conflict. So some sort of a dispute resolution was the main thrust in all our industrial laws. That is why we had our Industrial Disputes Act, etc. Then after 1990s, there was a sudden change on a fine morning, and it went to an equally damaging another paradigm. When the capitalist paradigm was introduced in India in the name of globalization, it said industry minus labor. That was the paradigm. So industry said that labor need not be considered in labor laws. Labor is an hindrance. Labor cost has to be reduced. So all these things came up as a part of that globalization, the idea of globalization. But we should understand that before legislating labor laws, we have to take into consideration one important aspect. That is, India is a founding member of International Labour Organization, and International Labour Organization has set international labour standards on each and every aspect of labor. So every provision in labor law should reflect the international labour standards set by ILO. ILO sets the international labour standards in the name of convention. They are all resolutions passed by ILO, which will be ratified the parliaments of the member countries. India also has ratified nearly 47 labor ILO conventions. So India is bound by such conventions and also the basic principles of ILO. So ILO has is trying to promote a paradigm on two aspects, that is sustainable enterprise and decent work. Is bound every such convention. Industry should have a sustainable existence. So that is required. That should be one purpose for which labor law should be registered. Is trying to promote a paradigm. Second thing is every worker should be ensured decent work. That is also so. All the labor law all the ILO conventions were intended to achieve these two purposes of sustainable enterprise and decent work. So already there are about 190 conventions and 206 recommendations adopted by International Labour Organization. So decent work means decent wages, decent working conditions, decent social security, decent occupational safety and health, decent welfare, decent gender justice, decent dispute resolution, and decent right to organize and collective bargaining. So this is the concept of decent work, which the ILO want to ensure to every worker in the world of work. But unfortunately, one aspect that our country faces is in the economic field. Already our manufacturing sector is facing a slowdown. Indian market is captured by Chinese products. So we want an ease of doing business. So the easiest way is to reduce the labor cost. So this is going on. So because of that, from many quarters, if ease of doing is to be achieved, labor cost has to be reduced. For that purpose, labor laws has to be amended, and industry minus labor, that principle has to be pushed forward. Here, the conflict area starts. Now, because of that, the old labor jurisprudence has vanished from the face of labor legislation, and a new jurisprudence is slowly emerging. So let us look to what is that new labor jurisprudence and what are the conflicting areas in that labor legislation. The contentious labor law legislation started when Rajasthan government brought changes in 4 basic laws. They amended the ID Act, raising the threshold of Chapter 5B from 100 to 300. Then they raised the threshold limit of contract labor from 20 to 50. Then the threshold limit in Factories Act also was raised. And for registration of trade unions, the Rajasthan government insisted that they should have the support of at least 30% of the total workers in that establishment. So these 4 changes in 4 basic laws, that has created a lot of dispute, a lot of agitations, etc. But there was a trend in which other states also started adopting the Rajasthan model. But later, Rajasthan model became a political failure. So after that, the central government also started a sort of labor law changes. Without consulting the trade union, they passed 2 laws, and they passed a 3rd law, that is Factories Act. But it was sent to the Parliamentary Standing Committee, where the Standing Committee said it should be brought to the Parliament only after consulting the trade union, because Indian Parliament has already ratified a convention of ILO C-144, which says every change in the labor law should be consulted with the stakeholders, that is 3 partners, the trade union, the employer organizations, and the various state governments. So that is not adopted. So that procedure is not complied with. So it should be the Factories Act amendment was returned back for consultation with the trade unions. Thereafter, the central government came up with a Small Factories Act, that up to 40 workers, those factories having up to 40 workers, they will not have any maternity benefits. No safety provision is compulsory. ESI and EPF will not be there. Bonus will be the minimum 8.33, nothing more than that. So these amendments were brought, and it was vehemently opposed by BMS. In the discussions, we said we cannot compromise on any of the fundamental things in labor law. So after several deliberations, the government withdrew that Small Factories Act. Then came the codification of all the 44 central laws in the country into 4 codes. The 4 codes are the Code on Wages 2, the Industrial Relations Code, 3, the Code on Social Security, and 4, the Occupational Safety, Health and Working Conditions Code. So these 4 codes, in fact, contains, as claimed by the government, that it contains almost all the provisions of labor in the country. It is not easy to go into each and every provision because all the 4 codes are voluminous. So only I will mention some of the highlights and some of the contentious issues involved. Now, what is the purpose of codification? Codification, the purpose is, one main purpose that is mentioned by many of the committees is that it should have a universal nature. The provision should be applicable to all the workers, the last worker in the country, the last industrial unit in the country, every activity where there is an employer-employee relationship. So it should be universal. So in Bangalore water supply case also, Justice Krishnaiyer has put forward this idea that labor law should apply to all the last worker in the country. Because of our discussion with the government, our deliberations, the wage code, the code on wages, that achieved this purpose. Out of the 4 codes, code on wages and the first draft of Social Security Code, these 2 codes have tried to achieve this universality. The labor code on wages that ensures the last worker in the country the right to minimum wages. This is a historical achievement. So in that sense, wage code is historical. Another historical aspect of wage code is that there is one section 52 which says that if minimum wages is not given to a worker, the worker as an aggrieved party can directly approach the court. This was not there with regard to minimum wages. That is so, in that aspect, code on wages can be instrumental in ensuring minimum wages to the last worker in the country, thereby increasing the standard of living of the common man. And that will also have an impact on the economy. That is the one analysis about this code on wages. But unfortunately, Occupational Safety and Social Security Code, these 2 codes are not universal. It can be said that they are only mere cut and paste of the existing law. It is also not a good cut and paste, it's a poor cut and paste of the existing laws. Even though there are many plus points in the codes, there are many minus points. In the plus points, we can say that it has in the Social Security Code says it covers new forms of employment like gig workers, platform workers, that is the Uber, Ola, then Zomato, Swiggy, that type of workers who have no direct relation with the employer. They are connected to the employer through the online electronic media. Then in the first draft of IR code, agriculture was exempted from the purview of IR code, but BMS strongly wanted that also should be included. Now in the later code it is included. Now there are 2 categories of workers which is excluded from the purview of all the labor laws. One is apprentices, both in the definition of employer as well as employee as well as worker. The apprentice has been left out. They are omitted. It includes except apprentice. That is what is mentioned. Similarly, the managerial, supervisory and administrative cadre workers, employees, they are also not covered by the 4 codes. So BMS has demanded that apprentice should be covered. This supervisory type of people also should be covered, because apprentices are working in dangerous machines, near dangerous machines. So if some accident takes place, definitely they should be covered by the law. So they are also human beings. So we want apprentices are employed in many places for long years, for years together. So they should also get the benefit of labor laws. Now, another shortcoming of the occupational safety code and this social security code is that the threshold limit that exists in the labor law, that is retained there. For example, in contract labor, below 20 workers, the Contract Labor Act doesn't cover. Similarly, in OSH code, it applies only to establishments, units which have 10 or more workers. Similarly, in building construction also, 10 or more workers are required for the provisions to be covered. Similarly, in many other provisions also, this threshold limit is retained. So BMS has demanded that threshold limit should be totally removed, and even when one worker is employed, they should get the benefits. One reason for such an argument is that previously those industries which were engaging 100 workers, because of mechanization, artificial intelligence now coming up, those factories can now work with 10 workers. They can produce what they were producing about 50 years ago with 100 workers. They can produce with 10 workers. So the threshold limit actually should have been reduced instead of increasing. Similarly, there are wage ceiling on many benefits, especially in the social security benefits. For example, ESI, there is a wage limit for including in the ESI Act. EPF has such provisions. Bonus law has that provision. Then gratuity also has such provisions. So all the wage ceiling should be removed. Anybody who is an employee, who is a worker, should get the benefit of all the laws. Another long pending demand of trade unions is that social security should be ensured to the last worker in the country. Social security for all. In the first two drafts of social security, this was included. It was a universal code. But there were two shortcomings, that ESI and EAPF, which are running well in the country, they were being included in the honor sector social security scheme without any government contribution. That means all these contributions that the worker in the organized sector has given, that will be diverted to the unorganized sector. This is called cross subsidy. The organized sector people subsidizing the unorganized sector. This should not be there. Organized sector, they are paying for their own benefits, and for the unorganized sector, government has to subsidize. So mixing up these things will be fatal when the beneficiaries in the organized sector claim their benefits at the time of retirement, etc. There will not be any paisa left in the EPF type of funds. So we said ESI, EPF, building construction, and some of the welfare schemes which are running well, they should not be at this point of time mixed in with the unorganized sector welfare fund. At a later stage, when the unorganized sector also is raised to that level, they can be mixed up. But this debate went on for a long period, and thereafter, in the third and fourth and the latest draft, the universal nature of that code has been removed. Now it is only a cut and paste of all the existing social security laws. One major issue of contention, not only from the worker side but also from the employer side, is the employer liability is retained in the social security codes. When social security insures for all the industrial accidents and other calamities, three categories are left out from that area, and it is retained in the personal liability of employer. That is maternity, gratuity, and employment injury. These three areas when something happens to the worker, the employer has to personally pay. It will not come from the ESA or from the Social Security Fund. This also we have objected. Another two good things that have come in the Social Security Code is that the medical bills of the worker, that has to be reimbursed by the employer. Another thing is the notional extension of workplace. When the worker is going to a factory and on the way he meets with some accident, that also should be covered by the Social Security Code. Another demand of the trade unions is that every worker should be ensured safety. Safety should be for all. That was the demand. But unfortunately, Occupational Safety and Health and Working Conditions Code, it's only a cut and paste of the existing safety laws. Now our safety laws are very old and they were only confined to certain limited sectors. But now we find in many sectors this safety is a very serious concern. People are dying in drainages. There is no safety law. They are dying in illegal mines. Even the Visakhapatnam tragedy, we know how the people also should be given a protection. So in many areas, building construction area, it's also unsafe workplace. So all these areas should be covered. So every sector has safety issue. Motor transport, there is safety issue. So there should be a comprehensive law covering all the sectors where people are working. So safety for all should be ensured, but unfortunately that did not take place. Now the Occupational Safety and Health Code is only a cut and paste of the existing safety laws. Moreover, it also says that you should have at least minimum 14 days experience working for getting eligibility. That is also bad, because on the first day, if he meets with some accident, so he should also be protected from by safety provisions. So there should not be any minimum 14 days for Social Security or any such law. Similarly, the scheduling system, that is also to be removed. Hazardous processes, it doesn't apply to all hazardous industries. Only those industries listed in the schedule, they will be considered as hazardous. So we also demanded that scheduling system should be removed. Hazardous should be defined. All those industries, units coming under the definition should be covered. Then there are some exclusion provisions. For example, what I said about schedule. But in some courts, there was attempt to remove that schedule. One good thing is that the Code on Wages, it has removed all the schedule system. At present, minimum wages will be ensured only to those industries which come under which is enlisted in the schedule. Now that has been removed. All the schedules are removed, and all the workers, the last worker in the country will come under certain scientific pattern of minimum wages. So the schedule system is removed in the Code on Wages, but it exists in the other codes. Another thing is that the government is still given arbitrary powers to exempt any industry from the purview of labor laws, any unit from the purview of labor laws, or any provisions of the labor laws. This also we have opposed. We should not create lawless areas in labor laws. In certain areas there is no labor law applicable. That is not a good thing. Another important aspect is which is done in most of the economic areas is formalization of industrial units and formalization of workers. So after coming of GST, most of the units in the country, industrial units, economic units, are now formalized. They are all registered. But in the for the purpose of labor laws, every unit need to be registered. So the Social Security law says every unit, even if the social security code doesn't apply, they should be registered. That's a good thing. But occupational safety and health doesn't say that. They say only those units which have more than 10 workers, they should be registered. So, in addition, BMS also is demanding that every worker should be registered. Every worker should come into the statistics. They should become visible. When we were discussing about the pathetic condition of migrant labor, one aspect that came up was that the government doesn't have a statistics about how many workers are migrating from one state to another, how many migrant workers are working in the receiving state. There is no statistics. So every worker should be registered. Now he can be registered electronically. He should be given a portable card because migrant workers are migrating from one place to another. So there should be a portable card which can be used for social security and other purposes. And every worker should be given written job letter. That also has been accepted. These things are accepted in the courts. But one more demand: everybody should be given salary slips. That is not included in the labor codes. That also is very much required. Another contentious issue in the labor codes is the right to legal remedy is limited. For example, when the entire civil law in the country says you can execute a award, a judgment, a decree within 12 years, the labor code says, the industrial relations code says the execution should be done within 1 year. Actually, the awards are passed after a long battle, long years of legal struggle. But after that, if he doesn't execute it within 1 year, that will lapse. So that provision we have opposed. Another thing is domestic inquiry is very vital in labor law. So when a domestic inquiry is conducted and it is challenged in the labor industrial tribunal, then this IR code says no fresh evidence shall be taken. Whatever is evidence is taken in the domestic inquiry, that cannot be challenged. That should be taken. No more further oral evidence or other evidence should be taken in the industrial tribunal. Industrial tribunal should only act as an appellate court. This we have opposed. Another thing is regarding standing order also, no oral evidence can be taken by the approving authority. Similarly, if after a long battle, in the legal battle, awards are passed, the government is given arbitrary power to cancel that awards. That also we have opposed. Then the complaint under industrial relations code can be filed only by government officers. It cannot be filed by aggrieved parties, except in labor code. This is the position. Except in labor code on wages, this is the position. So worker should be given, the aggrieved party in all the civil laws in the country, in all the other laws in the country, the aggrieved parties can complain to the authority. In all the penal laws, aggrieved party can approach the magistrate court. The same power should be given to the aggrieved party for complaining, for prosecution. And also this complaint also has to be filed within 3 months. After 3 months, no criminal complaint can be filed under the labor code. This also we are opposing. Similarly, for compensation, in the first draft of IR code, it was 45 days. But now that has been changed and it is 15 days compensation has been retained. Another thing is, in case of termination, etc., we can challenge it before the labor code with authorities. But the termination otherwise, that word has been dropped. So an oral termination, that cannot be challenged right now. So we have asked to include termination otherwise also in the provisions. There are some good legal aspects coming within the labor codes. One is, now we have a a dichotomy in the court judicial system. There are labor courts, there are industrial tribunals. Now these two are clubbed together in the new IR code, and now there is only industrial tribunal will be there. All the labor disputes will come for trial or for this thing in the industrial tribunal. That's a good thing. Then at present, awards when passed, they have to be published in the Gazette. That system is now removed, and awards will be directly given to the party, like in civil and other courts. Similarly, report of the conciliation officer. Now what happens when the conciliation fails or succeeds? It will go to the government only. The party doesn't know what is in the report. Now the conciliation report will be directly given to the party. And one good thing that one good consequence of that thing is the aggrieved party can directly approach the industrial tribunal. At present, it has to pass through the long process of reference. The conciliation report will be presented to the government. Government will examine it. It will take a long time. After a long period, it will be referred to the labor court or industrial tribunal. That process is removed. Now you can directly approach the court. This is also a good thing. Similarly, execution. You can execute an award like a civil court with all remedies available in the civil court. Another demand we have raised was the labor court or the industrial tribunal in the new labor courts. They should have the power to give interim relief. That was discussed several times, and finally that has been included in discharge dismissal cases only. We have demanded that should be extended to all disputes coming in the labor industrial tribunal. Now the powers of the conciliation officer also has been changed. At present, what happens if the worker raises a dispute, the conciliation officer will issue notice to the employer. The employer may or may not come. He can ignore the notice and he can keep quiet. But in the labor code, the conciliation officer can enforce the attendance of parties. So parties cannot now say that I cannot come for conciliation. That is a good provision. And failure report can be directly given to the parties. That is also good. And in certain cases, the conciliation officer has the power to investigate. That is also a good provision, because in many cases that is required. What is the truth? That truth has to be found out. Another most contentious issue that has gone up to the international level at the ILO forums is withdrawal of inspection system. Now, in the initial drafts of the codes, the inspector was replaced by facilitator. There will not be any inspector. It will be the job of inspector will be done by a facilitator. Facilitator means he is a toothless tiger. He can only advise the employer. If employer violates some labor law, he can only go and advise the employer. And even if there are little inspection rights are there, that should be web enabled inspection. Previous notice has to be given to before inspection. Then prior permission has to be taken from higher ups. That is all required. But that matter went as a complaint to the ILO. ILO also directed that India has ratified a major convention on inspection, C81. So India cannot violate that convention. It cannot legislate something against that convention. So inspection system has to be reinstated. So now at present what has happened is all the labor codes, 4 labor codes says inspector cum facilitator. That is the word used. So both ILO convention also has been complied with. At the same time, this advisory nature of inspector, that also has been retained. Another thing is instead of inspection, the employer organization said that it should be replaced by self-certification. Self-certification means every employer gives a certificate that in my unit everything is perfectly done and we are complying with all the labor laws. If that certificate is there, no more inspection is required. Only when there is some complaint, inspection has to be done. So the role of inspector is there are many non-unionized units in the country. Majority of the units in the country are non-unionized. Nearly 93% of the workers, they are unorganized. So inspection, government department, government's assistance is required for these people when there is violation of labor laws. Another thing is in small units also this assistance of labor inspector is required. But the complaint is there is a inspector raj. It increases corruption, etc. Okay, if there is corruption, it has to be addressed in a different way. Anyway, the inspection system can be the best way replaced if the power of inspector is given to the worker and trade union. So that was that system is prevailing in many developed countries. So BMS also has demanded before the government this aspect, and we raised this issue in the discussions. And finally, in the labor code on wages that has been approved, so the powers of the inspector to prosecute the employer, that has been now given to the aggrieved worker and also to the trade union. Now, another aspect in the inspection system is regarding migrant workers. There is a law called Interstate Migrant Workers Act of 1979. In that act, there is a peculiar provision. There, the sending state can appoint inspectors who can go and inspect the go to the receiving state and inspect the workplace. This is a very strange provision. That is also very much helpful, even though it is not implemented widely. It is a very helpful provision, but that has been avoided in the new code. Another big issue that is engulfing the whole labor sector is increasing casualization. Contract labor is increasing. Nearly 85% of the industry is now going to contract labor, and permanent workers are vanishing. Within 10 years, there will not be any permanent worker in the country. That is the speed in which this casualization is going. And the workers are keeping exploitative types of workers in the name of trainee, apprentice, badli, contract, casual. In these different names, such people are being retained who has no existing rights of labor law under the labor laws, which is given to the permanent workers. So for the purpose of avoiding labor law rights, the workers are being retained in different names. Apart from this, a new category of workers also has come up, that is called fixed term employment. This has been included in the Industrial Employment Standing Orders Act. This has been included as an amendment. So in that case, a worker can be terminated without any notice. That is a very highly exploitative provision. So because casualization, exploitative nature of work has increased throughout the country. This is one aspect. Apart from the issue of exploitation, the casual nature of workers, that is affecting the industrial development also, because a worker without sufficient experience, skill, they are employed for a short period. So by the time they acquire skill and experience, they will be going to another job which is a totally different one. So because of that, below quality jobs are increasing in the labor sector. So because of that, many industries are now failing. One classical example is textile industry, which had permanent experienced people working previously. Now it's all filled with contract labor and labor who has no experience at all. So because of that, the entire textile industry is now being shifted to countries like Bangladesh. So casualization affects industrial progress also. Now, because of that, the second National Commission on Labor has said that for more than 1 or 2 years, a person should not be retained as badali, casual, apprentice, etc. So, regarding badali, for layoff only, the provision says that a badali cannot be retained more than 1 year. Similarly, another big issue in the contract labor sector is equal pay for equal work, which is a principle laid down by the Supreme Court, reiterated by Supreme Court. There is a provision in the existing industrial disputes rules, Rule 25, which says equal pay for equal work should be ensured to all workers. That is a substantive law which is now remaining in a rule. That should be, we have demanded that substantive law should be in the code itself. So we have demanded, but that is so far not included in the code. Similarly, because of the casual nature of jobs, the compensation also should not be given with some limitation of period. For example, in gratuity, minimum 5 years of working is required. Because of the entire job nature is changing to casualized nature, then this limit of 5 years, that should be removed. Even for 1 year, you should be able to pay gratuity. That we have demanded. Then another thing is the muster roll insists that it should only the permanent worker should be in the muster roll. Now most of the workers, 80-85% of the workers are contract and casual people. So every worker working in an industry, their name should be in the muster roll, not only permanent workers. Similarly, in Interstate Migrant Workers Act, there is a provision that from the time of recruitment, a person is considered to be in job. That provision is not retained in the contract labor. It is a new occupational safety and health and working conditions code. Similarly, the liability of principal employer to pay, that has been included in payment of wages and social security. If the contractor doesn't pay wages, doesn't pay social security, then the principal employer has to pay it, and it has to be recovered from the contractor. That provision is there. But regarding migrant workers, the displacement allowance in their law, that is not retained in the new code. Now coming to the tripartite culture in the country, it is very important that social dialogue should take place. The Prime Minister himself, when he came for the second time, Narendra Modi said there should be a spirit of synergy in every field. It is very important in the labor sector. Every issue related to labor should be discussed in a tripartite forum. So a tripartite mechanism is established throughout the world by the efforts of International Labour Organization, ILO, and in our ID Act also that is there. But sometimes in the labor codes, this tripartite spirit is missing. In some areas, it has been widened. So that is also very much very important. And when you look at the success of tripartite mechanism, ESI and EPF, they are two of the largest social security schemes in the whole world. They are running successfully. Even though on minor things we have some differences, still they are most successful social security schemes in the world, because it is managed by tripartite body where there is adequate representation of trade unions. So each and every issue at the lower level will be immediately conveyed to at the board meetings. So they could improve. Every time improvement can be made, and that's why it is working well. But there is a trend in the later legislation. In the recent legislation, there is a trend that these tripartite boards are replaced by advisory boards. The building and other construction workers, that board under that act, that is a typical example. It is only an advisory board. Advisory board cannot be treated as a tripartite body because it is a toothless board. The tripartite body means it should have the power to administer, to manage the affairs of the particular sector. In the OSH code, the safety board is there. That is not a tripartite board. It is only an advisory board. Similarly, at the same time, at the lower level, they have made some bipartite safety committees. That's a good thing. Another important thing, a new development, a new step in IR code is there is a entire chapter is devoted for bipartisan. For a healthy industrial culture, the employer and employee should frequently sit together and sort out their issues without the interference of a third agency. So at the unit level, at the floor level, there should be some bipartite mechanism. So the new code envisages for large industries work committee, which is in the ID Act, and for small establishment having more than 20 workers, there will be a grievance redressal committee where employer and employee representatives will be there. So whenever a small issue emerges, immediately the committee will sit and sort it out. That's a good thing. Only if the bipartite mechanism fails, then only the tripartisan, there is the government intervention, the labor department will intervene. So this is a good system. This was a proposal by Bharatiya Mazdoor Sangh because BMS believes in industrial family, Udyog Parivar. Because of that, we want always a congenial atmosphere, a culture of family, a family-like atmosphere in every unit. For that purpose, this bipartite mechanism will be very much helpful. If it fails, of course, the tripartite mechanism can step into. Another issue now coming up in the not only in labor laws, many of the legislation is that the laws are drafted by not legal experts but by the bureaucrats. So bureaucrats generally it contains a bureaucratic bias also. So many of the tripartite bodies in that the seats of tripartite constituents are now being replaced by bureaucrats, technocrats, some people in the name of advisors. So the representation of trade unions will be reduced, and in that place these bureaucrats will be sitting. This we have strongly opposed. In the same way, the powers hitherto exercised by the parliament, that is delegated to the bureaucrats. Many of the courts provisions in the courts, they say instead of bringing an amendment to the at the parliament level, those amendment changes can be brought about by executive orders that those bureaucrats sitting in the government, they can, by a notification, they can change the law. That is also an aggression into the powers of the parliament. Now another important aspect that has come up in the codification process is the powers of trade unions are tried to be restricted. It started with in the EPF board, there was an amendment that was brought to reduce the number of trade union representatives from 10 to 5. Similarly, in the courts, there were attempts to have single union. The concept of sole bargaining agent was brought. Then single union has to be promoted. These are all against democratic principles. In a democracy, definitely multiplicity of parties is required. So even in a industrial area also, there is nothing wrong to have more than one trade unions. So the single union or sole bargaining agent, etc., they're all limiting the intended to limit the trade union activity. Similarly, in Rajasthan amendment, we have seen that even registering a trade union has become very difficult because you have to have minimum 30% of the total workers. In the code, it is 10%. Similarly, there is restriction on outsiders becoming office bearers of the trade union. It is limited to 1/3. Similarly, those who are holding office of profit, they cannot be office bearers of the trade union. In the same way, the code says how much membership fee you have to collect, what should be the method of collection. All this has been prescribed. It is all none of the business of the government to see. It is an internal aspect of trade unions. Every organization, charitable organization, society, etc., in the society, they are working with their own arrangements for membership fee fixation, collection, etc. So why only in labor sector it should be restricted? Another thing is, if a worker refuses to obey the strike call given by the trade union, no action can be taken against him. This is also intended to create split in the trade unions. So he can, even if any action is taken, he can claim compensation from the trade union. That is a provision in the new act. Then there was a proposal to have one trade union leader cannot have more than the office bearership of more than 10 units. But later, because of objection from us, it was withdrawn. Similarly, there was a provision which was demanded by all the trade unions together, that there should be a deemed registration. Now, many places the government department refuses to register trade unions. It is being prolonged. They will not give that that your registration application is rejected. They will not. They will keep it as such. So we have demanded that after 45 days, the registration, if not rejected, it should be deemed as registered. So that provision was there, but later in the latest draft, it is also seen dropped. Another new thing that has come up in the IR code is there is a procedure for recognition of trade unions. That is not there in any of the existing laws. So at the central level and state level, there will be a procedure, there will be a verification process by which trade unions are recognized. There is another attempt to restrict the power of strike. Strike is the strongest weapon in the hands of trade union, but that is being restricted. Now, if you want to conduct a strike, you have to give notice of 14 days notice. Before 14 days, you have to give notice. Only after giving notice, 14 days after giving notice, you can go for strike. So by the time the employer will go to the conciliation officer, a dispute will be raised. Once the dispute is raised and conciliation procedure starts, then strike is prohibited. That means virtually no more strike will happen in the country. So this provision is also very strongly opposed by all the trade unions. Similarly, there is another provision, the code on wages, which is already there in the wage laws, in the previous wage laws. That is, if you go for illegal strike, for every day, 8 days wages will be forfeited. That also is retained in the new code. There was an attempt to bring strike ballot. That is, before conducting a strike, at least 51% of the workers of the industry, they should support it. There should be a strike ballot. Then only strike can be conducted. But after our objections, that provision was withdrawn. Now let us look into the social security provisions. What are the changes? What are the contentious issues, etc. In Social Security, the EPF contribution by the employer has been reduced from 12% to 10%. So that means at the end of his retirement, the total amount that the total savings of a worker, that will get reduced. Another thing is maternity benefit is only confined to a limited areas. The maternity benefit is a requirement of the mainly in the informal sector. People working in the rural areas, in villages, they should have maternity benefits. So maternity benefit should be extended to the last female worker in the country, but that is not included in the wage code. Similarly, Building Construction Act is there. Regarding that, the Supreme Court has given some directions. Those directions are not included in the code. Supreme Court said there should be uniformity in benefits, because it is a building and other construction welfare funds are in the domain of the state government. Many state governments have different provisions. So there should be a uniformity, the Supreme Court has directed. Similarly, there should be portability of your membership, because it's mostly building construction workers are migrant workers. So in one season they will be in one state, in another season they will go to another state. So their social security benefits, other benefits should be portable. So portability is to be there. Then implementation, when the benefits are to be given, that disbursement of benefits, that is not properly in any of the states. So there should be better disbursement. This is also direction by the Supreme Court. These are not, there is no express provisions for complying these aspects. Then there is a trend of shifting social security and other social benefits to the state governments. Central governments will not have that liability. All the social sector benefits and other development things, that will be entirely with the domain of state government. That trend was there in the labor laws also, in the codification process also, that came up. The recent laws like building and other construction workers law, that gives more thrust to state government. It's all implementation, everything is at the state government level. But in ESI, we have seen that state governments conducting ESI hospitals, that has become that is not up to the mark in any of the state. So we have demanded that the hospital system should be removed. ESI conducting hospital, that should be stopped, and the new way of cashless benefit stream, cashless health benefit, that should be implemented. But in the labor codes, especially in the social security code, the ESI, EPF staff and the funds were being transferred to the state government. The funds will be managed by the state governments. At present, it is managed by the central government, by the central ESI board. Now that will be transferred to the state government. This was in the first two drafts, but BMS opposed it, and now that is being retained at the central sphere itself. Similarly, minimum wage fixation was totally given to the state government. Now nearly 45 sectors, it is the central government which is fixing minimum wages. So both central government as well as state governments are fixing minimum wages. That should be retained as such, because many state governments are fixing minimum wages in a low level. That should not happen. Another aspect is, because there is wide difference in minimum wages in different states, this migration of workers take place. So to remove it and bringing all the states on par with each other, the best way is to have a national minimum wage system. That was the demand by BMS. It will be a little difficulty will be in the initial stages, but later on there will be an integration of all the states into that national minimum wages system. So for that, for compelling that thing, a national minimum wage system is required. But we discussed it in several consultations, and in the initial stage, the code on wages that contained that provision, but later it was converted into national floor level wages. It is a different system. It is something less than the minimum wages fixed by the state government. Only thing is that no state government can fix wages less than that national floor level minimum wages. That has been included in the statute. Now, ESI, there are 2-3 good changes brought about in the new Social Security Code. One is Section 42. There says, suppose the employer failed to enroll a worker into the ESI scheme, but he is eligible. Suppose he is not registered. Suppose his contribution is not paid by the employer. Still, if he is eligible, he is entitled for the ESI benefits, and ESI can reimburse the expenses met from the employer. So that makes every eligible worker should be enrolled in the ESI Act. So this is a good provision. This is going to be a revolutionary thing, because even though ESI Act is implemented, nearly more than 50% of the eligible people are not today enrolled in ESI Act. So that difficulty will be removed. Similarly, there is now a limit for ESI coverage. Less than 10 workers, if an establishment is having less than 10 workers, they will not be covered by ESI Act. But there are 2 exceptions given in the code for that purpose also. By voluntary opting, you can even units having less than 10 people, they can voluntarily opt in the ESI Act. Second thing is, in hazardous occupation also, without going into the number of workers, the government can extend ESI Act. These are the 2 exemptions included newly in the code. Similarly, EPF, EPS, EDLI schemes, etc. They are all applicable only if there are minimum 20 workers. Even if there are 20 workers, then also only those units which are included in the schedule. Now the schedule has been removed. So EPF, EPS and EDLE is applicable to every establishment where there are more than 20 workers. This is also a good move. Regarding gratuity, because of casualization, we have demanded that gratuity should be reduced from 5 years to 1 year. Everybody having 1 year experience should be given gratuity. Only in fixed term employment, the code says gratuity will be payable to every worker having more than 1 year experience. Similarly, in the first 2 drafts, there was a gratuity fund, a compulsory fund created by the employer. So at the time of retirement, if the employer say, I don't have money to pay you gratuity, that number of such cases are increasing every day. That can be avoided if there is already a fund where the employer is regularly contributing. So that gratuity fund can be used for giving. That was there in the first 2 drafts, but later that was dropped. In the present draft, that is not there. When coming to the wage issue, the definition of wage in the code on wages in many other codes, that excludes a long list of allowances. That is not something contemplated. That should not have happened. That is a thing that is opposed by the trade unions, because wage should include everything. All payments should be included in the wage. You should not exclude a lot of things. Then there will be a tendency to shift a major part of wage into allowance part. So that should not be there. Then regarding payment of wage arrears, the last drawn wage that concept has to change because after a long period of litigation, after 15 years, if the final verdict comes, then last drawn wage means it will be about a wage level of 15 years before. So the existing wage level of the same job at that at the final stage, that should be the that should be criteria for calculating the wage arrears. That is the demand that is not met. Then one good thing is payment hereafter will be done only through banks. There will not be direct payment. That system will be removed. Recently, the issue of working hours was discussed widely when nearly 14 states in India they raised the working hours from 8 hours to 12 hours. In one state it was 11 hours, another state is 10 hours. So in the previous draft of occupational safety and health also there was a proposal for 12 hours, but because of that we opposed it, and because of that has changed. Now it is mentioned as the government can, state government or central government can, by notification they can fix the government. That is also equally a objectionable provision. And there was a provision for spread over for 14 hours in the previous draft. It was inhuman because a person is spending his time 14 hours in a factory, then he has only 10 hours left. That includes his travel from factory to his house, taking rest, his engagement with his family. For all these things, only 10 hours is left. It's inhuman. So they have removed it. But because of the provision for arbitrary power to fix wages, many state governments will go to such inhuman level of fixing wages. Similarly, overtime in a week, that was raised from 50 to 100 hours. And the government can even go up to 125 hours. That was the in the draft that was there. We opposed. It's all inhuman to have such high level of working hours, especially when previously people could work with 8 hours. Now it can be worked because of mechanization and other things. That productivity can be done with 3 hours or 4 hours because of machines. So working hours in Japan, in countries like Japan, when there was large unemployment, they reduced the working hours from 8 to 6 because more hands will be getting jobs. For that purpose, they have reduced even working hours. So increasing working hours, that will impact the employment generation also. Similarly, in the Apprentice Act, there is a provision whereby the employer can arbitrarily fix the working hour of a apprentice. This is also not something good. So one more demand BMS has raised, that is flexi time. The concept of flexi time has to be introduced in the OSH code, but that is not so far accepted. The worker should have the choice of fixing his working time. That will be more productive. That will increase the productivity, because according to his mood he can work. In many establishments in the IT sector, etc., it is already started. When you are working from home, then also you can have your own choice of working hours. So flexing time also has to be introduced. That is good for the industry. Another provision in the previous draft of OSH code was night shift to women workers. In many places, factories are located in remote places, so where women cannot travel at night. Even daytime, their security is affected. So at night time, it's very difficult to travel. So compulsory bringing night shift was opposed by BMS in consultation, and later on, that was now in the latest OSH code, that night shift is avoided. Another thing is there is a new trend of government withdrawing from the labor welfare. So everything is given to private sector. So in the previous Social Security code, the Social Security responsibility was given to private sector in the name of intermediary. Because of our objection, that has been withdrawn. Similarly, the government has to pay to EPF 1.16 percentage for to the employees pension scheme, EPS scheme. But in the new code, that is not there. It is missing. Similarly, there was an attempt in the previous draft to convert employees pension scheme to new pension scheme, EPS converting from NPS to EPS to NPS. But because of our objection, that is also now withdrawn. Similarly, there was a attempt to provide opting out of ESI. You can go to private health schemes, but no health scheme in the entire world is better than ESI scheme. With such a low premium, you cannot get such large benefits. So the opting out of ESI also was opposed, and that also has been proposal also has been withdrawn. Similarly, another trend in the EPF board meetings is EPF amount. There is a large lakhs and lakhs of rupees remaining in the EPF fund that is being diverted to risky share markets. That also has been opposed by BMS. Similarly, in many welfare schemes, the revenue is generated through cess collection, and many cess-based welfare schemes, cess system is withdrawn after the advent of GST. There also that those welfare schemes are in a troubled position. And regarding social security, if you want to give social security to the last worker in the country, social security for all, then our government has to provide at least 10% of its budget allocation to the social security fund. In many developed countries, it is up to 25% of the budget allocation. So at least we should have, now we have a very low budget allocation to social security fund. That has to be changed, and at least up to 10% should be given to budget allocation. Then only the 93% that comes to nearly 43 crores of people, working population. If social security has to reach them, the government has to increase their budget allocations. Now there is the issue of implementation. So portable Vikas card, that is a proposal in the social security. That is a good thing. Then another thing is, one good thing that is included in the social security code is that worker facilitation centers are entrusted with the task of enrolling the workers. That will be intended at the local government level, at the local panchayat municipality level. If enrollment starts, then it will have a wide coverage. Then only social security can reach the unorganized sector. That is also good thing. Another thing is regarding punishment. The new trend is imprisonment is being reduced and fine is being increased. For first offenders, decreasing imprisonment or avoiding imprisonment is there is nothing wrong. But subsequent offenders, they should be strictly dealt with. There is also compounding portion of offences. If you pay the 50% of the penalty prescribed, the offence can be compounded. That also for first offenders only. That is also in the provisions. Another problem with this codes is there is poor drafting of codes. Now, previously, legal luminaries were involved in drafting legislations. Now that system is gone. Even in Parliament, discussions are taking place within a short time. Previously, clause-wise discussion took place. Now that also is not there. Many laws are passed without sufficient discussions. Similarly, the drafting is done by bureaucrats In Social Security Code, you will find 143 definitions in the previous draft, because our objection that now that has been reduced. So same word is defined in different chapters in different ways. So these are all the Anglo-Saxon systems still continuing in many, not only labor legislation, in many legislation that is continues. And one code is contradicting the other code. That is there. There is no uniformity of provisions in various codes. Various definitions in one code will differ from the definition in another code. Similarly, even the worker is categorized into two types, employee and worker. Employee means more privileged people and worker means unprivileged people. So that classification also is very unscientific. Similarly, tribunal, court system that has been abolished, now only industrial tribunal is there. Similarly, definition of wage, worker, industry dispute, etc. It varies from one code to another. Even the name of the code, that also two codes have says code on wages, code on social security. In two other codes, it is industrial relations code. Then the word code comes at the end in two codes and at the beginning in two codes. So even in names they could not bring the uniformity. So these are all some things. Another thing is all the substantive provisions which creates rights among the workers, that should come in the code itself, in the act itself. But unfortunately, in the most important substantive right giving to contract labor, equal pay for equal work, that is in the rule, industrial disputes rules, rule 25. So same provision is now being repeated in the code also. And besides increasing the complexity of legislation, when you look at there is a code is there or the act is there, then there are rules are there, then there are schemes there, then there are regulations, then notifications. So all these things, acts, rules, schemes, regulations, notifications, etc. These are all increasing the complexity of legislative process. So all these should be reduced, and we should have a simplified and codified system of legislation that is not achieved by this codification processes. Even there is wrong quoting of provisions in the code. So these are all to be rectified. And even codification system is also wrong. In the occupational safety and working condition code, two entirely different things are clubbed together. Occupational safety and health is one thing, working conditions are totally different. If at all it is to be included, it should be associated with the IR code, but it is clubbed together in OSH and WC code. Similarly, welfare was a part of Social Security Code in previously. Now welfare is dropped from the Social Security Code. Many laws in the country are still outside the purview of these codes. For example, shops and commercial establishments, then Explosives Act is there, Electricity Act is there, then law relating to apprentices. These are all not included in the codes. These are there are similar provisions in the code, so there will be contradictory provisions in the code as well as in these laws. So that codification also has not encompassed all the provisions related to labor in the country. Now, lastly, one major issue that has come up is the suspension of labor laws in 3 states. In Gujarat, except minimum wage, safety law and employees compensation law, all the labor laws has been withdrawn. So it's a lawless area in labor sector. In UP, except minimum wages act, safety provisions, injury compensation, women and children, and bonded labor, all the labor laws are withdrawn. Only in UP and MP, the suspension of labor laws will apply only for future units, future investment coming, future units being established. Only for them it will apply. It doesn't apply to existing units. But in Gujarat, it applies even to existing units. So after these changes, what is the condition there? Now all the trade unions are become illegal because there is no Trade Union Act, there is no EPF, there is no ESA, no pension, no migrant worker protection, no health and security, no dispute settlement system, labor machinery is suspended, you cannot go to the court, no norms of working conditions, then you can fire a worker at any time. There is no limit for working hours, no weekly holidays, no leave, no bonus or gratuity, no protection for contract labor, no protection to journalists, and not protection to migrant workers also. So this is the tragic condition of these three states. So we should understand that rule of law is fundamental to every civilized society. This suspension of labor laws is also against the constitutional provisions of fundamental rights, then directive principles of state policy. It's against these two things. They are all fundamental to constitution. Then it is also violating nearly 47 ILO conventions that has been ratified by Indian Parliament. So no labor law can be against these ratified conventions. That is a position. So it is also violating that thing. Then there is one act, the Interstate Migrant Worker Act. That is the union law. Even that laws has been withdrawn. ESA, EPF, these are all coming under central union list. That also has been withdrawn. So many of the labor provisions which is in the union domain, that also being withdrawn. How can it sustain in a constitutional legal scrutiny? So that is there. So what BMS has demanded is, first there should be bureaucratic reforms, because this process of license, registration, returns, etc. has to be simplified. Everybody should be within 24 hours, you should be able to register a company. That is not possible today because of bureaucratic hurdles and red tapeism. So first we require bureaucratic reforms to attract investment and to create new industries. So that way we have to think, instead of curtailing the labor rights. Labor rights are human rights. That is the principle now recognized worldwide. So in this way, a new thinking is required in the labor sector. I hope some of the highlights which I have mentioned will instigate your thoughts to think differently and let new normals appear in the labor sector. With these words, I conclude. Thank you.